Let me just take a moment here to welcome Angel Booth, Senior Sales Executive at Premier Reverse Closing, who is going to host our next session. And welcome, Angel, and thank you so very much for all that you and your company does to support Normala and this industry. We greatly appreciate it. Thank you very much. Over to you.
Absolutely. Thank you, and good morning to you too. Hi, everybody. Good morning. My name is Angel Booth, and I'm the Senior Sales Executive for Premier Reverse Closings. I'm approaching my 20th year in the mortgage industry, reverse mortgage specific, and I have experienced and seen a lot, to say the least. So right now, we just want to say thank you to all of our vendors and clients for your continued partnership and support as we close out yet another record-breaking year. We too are one of the industry's most trusted and respected national entitlement settlement companies providing service in 48 states, and we certainly appreciate the opportunity to participate in today's session. We miss seeing you all in person, and we hope that we're going to be able to change that in the near future. Today, I'll be introducing some industry favorites to our Compliance Corner session that are simply a wealth of knowledge and experience. First, allow me to introduce Ellie Johnson with All Reverse Pro. Ellie has committed over 40 years to reverse mortgage banking and has spent the last 27 working in an executive capacity. She's worked with several industry reverse mortgage originators and service providers. She's also the owner and president of All Reverse Pro. Ellie is extremely active with Normala as she serves on the board of directors and is even co-chair of the Normala HUD Issues Committee. Welcome, Ellie. We also have Jim Milano with Weiner Brodsky Kidder PC. Jim is a proud member of the law firm of Weiner Brodsky Kidder PC. Practices on mortgage banking, consumer finance, financial institutions, as well as mortgage and secured transactions law. As a co-general counsel to Normala, he is also one of the leading lawyers in the area of reverse mortgage law. Jim's practice is comprised of matters involving marketing, origination, investment, and the servicing of reverse mortgages. Welcome to you as well, Jim. And with that, I'll hand it over to the both of you.
Thank you, Angela.
Thank you, Angela, for that introduction. And welcome, everyone. Thank you for joining. I wish we were all face-to-face, but I'm certain that we will be together again very soon. I want to introduce the agenda of our panel today and the topics we will cover. The agenda is on our panel today. We'll focus on what activities are allowable prior to counseling. And while we want to start with a focus on FHA HECM rules, we will also cover and address other rules, both under other federal regulations, such as RESPA, TILA, ACOA, as well as state law requirements. So while the FHA HECM rules only apply to HECM loans, these other rules under federal and state laws apply to all reverse mortgages, including HECMs and non-FHA insured loans. So in today's panel, we will discuss HECM rules on application processing, state rules on reverse mortgage application processing, the timing requirements under RESPA and TILA, and also under ACOA, the Federal Equal Credit Opportunity Act, and the impact that the new HECM handbook that HUD published, and that comments are due by the end of this year, the impact that that new handbook will have on these rules, at least under the HECM perspective. I want to start out, however, by making a point. And that point is this: the rules we'll discuss today, like most laws and rules, are designed to implement policy and policy decisions. We know these rules make it hard on originators and lenders to do business, but trust me, regulators don't sit around and say, let's come up with a bunch of detailed hyper-technical rules that are going to make it hard on lenders and make originators' lives miserable. That's not the purpose or motivation of these rules or the regulators that propose these rules. Often, regulators are implementing rules based on laws that have been passed by a legislature, whether it's Congress or a state legislature. What regulators are doing in fashioning these rules, including the rules we're discussing today, is implementing policy decisions that have been made in certain areas. And in the area we're discussing today, mortgage loans, and in particular, reverse mortgage loans and HECM loans, that's what these rules were designed to address and policy decisions that have been made. Based on my experience in hearing HUD personnel talk about, in particular, the HECM rules we'll discuss today, I think the main policy issues are that HUD tried to strike a balance. As far back as 2004, over 16 years ago, and what they were trying to do was allow lenders to begin some preliminary processing of a HECM loan without the borrower either being obligated to proceed with an application for a loan or feeling obligated to proceed, and to assure that the borrower is not charged any fees or does not incur any fees or costs until after counseling is completed. So if you think about it in that context, HUD provided exceptions for lenders to get an early start, but it's mostly for the benefit of the borrowers. And think about it this way. HUD did not want every senior to go to counseling if it turned out they didn't own the home. That's what the preliminary title report is for. Or if they don't have enough equity, that's what an AVM was for. And HUD wanted to protect seniors not only in that sense, but also to assure that seniors did not incur any fees or feel obligated to proceed with the application until sometime after counseling, if even then. So in addition to the HECM rules that HUD put out on HECMs, we'll also talk about other federal rules and state laws and rules. And those rules have a similar policy purpose: to assure that the borrower does not incur fees or is charged fees until the borrower officially asks for and applies for a loan. In addition to those other federal rules, there are certain state-specific rules specific to all reverse mortgages about cooling off periods and waiting periods. And again, the policy behind that is to give the borrower time to consider a reverse mortgage as they get further into the process. The policy behind these laws, rightly or wrongly, it was that there was a perception that borrowers were being rushed through the process. I mention all of this because if you understand that policy and the motivation behind these rules, it may give you a different insight into what is the purpose of the rules and perhaps help you to better understand how you should approach these rules in your own operations. I want to turn it over to Ellie now to discuss some of the current FHA HECM rules on application processing for HECM loans.
Thank you, Jim. I think, Jim, I think it's probably safe to say that the guidelines regarding ordering services have certainly changed over the years. In the early days of the HECM product, no services could be ordered prior to borrower counseling. And there was even some school of thought, I think, that a lender could not take an application prior to counseling. With the introduction of additional safeguards and specifically financial assessment allowances have been made in this area. So as we all know, HUD's issued many mortgagee letters over the years on this topic. And I think several things are abundantly clear as it relates to an application and things that you can and can't do. Counseling is mandatory and must be performed by an independent third party who is approved to provide HECM counseling. And even more important, lenders are prohibited from participating in the counseling session. Lenders cannot pay for the counseling session, and also prohibited from steering borrowers to a particular counseling agency. In fact, HUD even cited an instance where they were told that a lender was with a borrower and had actually called the counseling agency together with the borrower and participated in the counseling session. So I think that sort of led HUD to make additional mortgagee letters and citings to make sure that lenders understood what they can and can't do as it relates to that. Again, they were, in this instance, they were very clear that a lender was to have no involvement in the counseling session before, during, or after the counseling session is completed. They go on to say that a lender may not contact the counselor or the counseling agency to refer a client, discuss a client's personal information, including the timing and the scheduling of the counseling, or even request information about any of the topics that were actually discussed in the session. So in Mortgagee Letter 2004-25, HUD announced very specific requirements around activities that were allowed prior to counseling. So when a potential HECM mortgagor first contacts the lender and communicates that the mortgagee must explain that the HECM program requires counseling, which we've talked about, and they should also refer the client with a list of eligible HECM counseling agencies, and with information on each of those counseling agencies, things like, where are they located? Are there those located within a particular radius of the borrower's home? Do they offer telephone counseling, things like that? And again, that mortgagee letter was also very specific that no steering was allowed at all. Next slide, please. Who's doing the slides? Okay, so Mortgagee Letter 2004-25, again, additional activities. HUD recommends and urges mortgagees to refer clients to counseling prior to taking an application. That's a question that's come up over time, and I mentioned earlier when I was talking and discussing the requirements. It's not required that the borrower is counseled, but HUD urges you and recommends that they're counseled before application. Many lenders do take the application first. However, if you decide to go ahead with that, there are certain things that you need to make sure that you do. Discuss the program with the potential mortgagor and explain the program and discuss whether the potential borrower is eligible. There are certain questions, obviously, you have to ask whether or not they meet eligibility. Provide information regarding the fees and charges associated with the HECM product. Describe potential financial implications of doing a HECM, and provide the borrowers with copies of the mortgage note loan agreement. Also, they're very clear the potential HECM borrower is not obligated to pursue the HECM loan from a lender who takes the initial application or discusses the HECM program with the potential borrower before they complete the counseling session. So it goes on to talk about the Mortgagee Letter 2004-25. The mortgagee may not order an appraisal, title search, or an FHA case number, or in any way begin the process of originating a HECM before the potential mortgagor completes the counseling. The mortgagee may only proceed to process that initial HECM out once the counseling is complete, as evidenced by the signed and dated counseling cert. Now, a lot of people would say, what does that mean? Mortgagee may only proceed to process the initial HECM loan out. Well, that goes into fees and charges and what you can and can't actually charge the borrower. So until the mortgagee receives that HECM counseling certificate indicating that the borrowers have been counseled, they may not charge an application fee, an appraisal fee, or any charge that is for any other HECM related services. So subsequent mortgagee letters have been issued, to further clarify a lender's responsibilities and provide updated guidance for activities that are allowed prior to counseling. And so one such mortgagee letter, of course, is Mortgagee Letter 06-25. So with that mortgagee letter, FHA would permit lenders to use automated valuation models that would perform a preliminary estimation of the value of the property. The AVM, again, does not take place of the FHA appraisal. And if the prospective borrower obtains the HECM, then the cost of the AVM could be included in the origination fee. So that's another big point there to make. You can't charge it outside like a separate fee. So there's a lot of fees that HUD says it's just a cost of doing business. So that would be part of your origination fee that you collect. In addition, a HECM lender may order a preliminary title search prior to prospective HECM borrower receiving counseling. Now I'm saying search here because we're going to talk about what the final, the draft document says later on and talk about the change in the terminology there. However, the prospective HECM borrower may choose to seek counseling prior to or after the lender orders that preliminary title search. In other words, that borrower does not have to wait until the HECM lender orders and reviews the title in order to receive counseling. The cost associated with this title search, preliminary search, will be paid at closing. Again, cannot charge the borrower anything up front, basically until the time of closing. So the other things that additionally, we talked about financial assessment and some of the other further guidance that added allowances for ordering a credit report, for example. So there's, I think, different things that we should consider as we go forward. When is an appraisal ordered and how is it paid for? No assessment of the fees or completed and final application until the counseling has occurred. What do your disclosures say? So if you're, if you're trying to charge a borrower for an appraisal fee, do you have a disclosure that states, specifically how that fee will be handled if the borrower doesn't go through with the transaction? What do your disclosures say? What are the state disclosure requirements? And then, of course, we're going to talk later about how does this draft handbook address some of these issues. So I think this is a good segue, Jim, into this next discussion that we're going to have about some of the state laws and some of the requirements for, outside of just what the HUD regulations are. Jim, you're on mute.
I'm sorry, I was going to say, Stephen Darrell, if you can keep it on this slide, I have a few things to address on this slide. I think we're okay on time. If you guys don't mind, I'm going to go through these questions that have come in. And Ellie, maybe you can chime in. The first one's from Renee Duvall, and she's asking, can they do a counseling without a specific proposal? I think so, but the counselor has to, the counseling agency has to obtain documentation from, a software system to be able to show presentations about a reverse mortgage to a senior. And Ellie, maybe correct me if I'm wrong, I think a counselor will ask what type of loan the senior's looking at so that they assure they have relevant documentation to go over with the senior.
That's correct, Jim. So HUD did make that change a while back that would require that the lender is to provide copies of the proposals so that that counselor has all the information necessary to counsel them appropriately on the particular product that they've selected.
Okay, and Tom O'Donohue asked, what is FHA's concern about steering for counseling? The rates charged range from 150 to 300. Maybe companies should all charge the same rate. And there's a general anti-steering provision in, I believe, the HECM statute and certainly the regulations and the mortgagee letters. I think the concern with steering is FHA wants the counseling to be, independent and wants, a borrower to be able to choose their counseling agency off of a list of a number of counseling agencies or intermediaries that's required to be given to a potential applicant. So I think there's concern about steering. I'm not sure that that concern is focused on potentially a lender steering an applicant to a higher priced counseling agency. I understood counseling range from 125 to 150, maybe it's more if there's more people that have to be counseled. But the steering, I don't think, is directly tied to the fees. It's more to make sure that there's not some arrangement, if you will, between a lender and a particular counseling agency. We have seen in our practice when HUD comes into audit, through no efforts of a lender, it just so happens to turn out in a particular area, consumers in that area end up getting counseled by one counseling agency, and HUD will flag that, and they will say it appears, all your applicants in this area are being counseled by one agency. They'll flag that as a concern. Cheryl Ann Miller says some agencies only charge 125. Sometimes grants are available. Jeff Foodie asks, can a borrower ever be charged an application fee? You know what? That's not clear. If you look in the handbook today, application fees are not a listed allowable charge. There is an old provision in an old mortgagee letter that's still effective right now, but Ellie, we may want to make a note and look at this under the new handbook that we'll be talking more about here in a second. There was a reference to an application fee in a HECA mortgagee letter many years ago. I don't see a lot of lenders charging application fees. I think the feeling or understanding is that the application processing work will be covered by the origination fee. Neil Schwerin, how are you doing today? Neil asked, can you tell your clients of agencies offering grants? That appears to be a very consumer-friendly public service. Unfortunately, I think that may touch upon steering. Brian, and I'm going to butcher your last name, Bellomini, asked about a processing fee. I don't think so. I think the processing, we talked about application fee, processing fees are not listed. I think the idea is that origination fees would cover the lenders, the originators' work. Pudge Erskine, good afternoon, good morning, Pudge. I think maybe you're on the West Coast. Thank you for your comment. I don't see that as a question, but Cheryl Ann Miller agrees with you, it appears. This is a new question. If a borrower has no means to pay for the appraisal, can the lender cover this with their credit card and the lender's required to collect the appraisal fee at closing? We're going to get into that. I'm not sure you mean the lender's credit card or the borrower's credit card. I think you need the borrower's credit card, and we're going to touch upon that right now. We're going to go on to some other slides. Gina Lesh, typically how appraisal fees handled. We're going to talk about that right now. Jeff thinks the application fee, hi Jeff Birdsell, thinks the application fee is included in the max origination fee. We'll come back to some of these other questions in a moment. I'll pick up with Jeff, but thank you, Ellie, for your overview of the HECM rules. In addition to the activities that Ellie covered, as she said, when FHA issued the financial assessment guidelines in 2015, they indicated that lenders also could order a credit report before receiving a counseling certificate from the borrower. And this makes sense from an early processing standpoint. In addition to, as Ellie discussed, needing to know if the borrower actually owns the property, you'd get that through a preliminary title report. And knowing if the borrower has equity in the property, you would get that from an AVM or some valuation, and asking the borrower if they have a current mortgage and how much they know, how much they owe, I'm sorry. Having a credit report will also feed into what the lender knows that they're going to have to do as part of financial assessment. So that's an allowed early activity. But as far as other rules besides HECM rules that we'll get into now, Ellie raised these questions, and they're good questions, and people are asking these questions in the chat room. When do you order an appraisal, and how's that paid for? This should be considered because the other rules we will address say, no assessment of fees or no taking of an application. In some cases, the verbiage under state law follows FHA rules, a completed and final application until counseling has occurred. And then as Ellie raised, what do your disclosures say? Some disclosure rules provide that a fee cannot be assessed by anyone, not just the lender. A fee cannot be assessed by anyone until 3 days after application disclosures are given. And I would answer the questions about appraisals with a question. How can you give an application disclosure if you do not yet have an application? And we'll also discuss later on in this panel, probably in about 10 or 15 minutes, how the new draft HECM handbook addresses these issues and affects these issues. Ellie will discuss these issues near the end of our panel today. However, as we've said, it's not just HECM rules that we have to worry about and comply with. There are other rules, and the interplay of those other laws and regulations have a significant impact on your operations. You need to be aware of those rules. You need to know those rules. You need to be cognizant of those other rules and assure that they're in your internal operational policies and procedures and that you're following them. Next slide, please. So state laws, in addition to the pre-application counseling requirements in over a dozen states, many states have counseling requirements for reverse mortgages beyond what's in the HECM rules. It applies to all reverse mortgages. Some states say, a few states say, if it's a HECM loan and you comply with HECMs, or if you comply with the HECM requirements and it's not a HECM loan, that's okay. But I said over a dozen states, it's probably in the low 20s states that have rules on counseling. And some of these states have no other rules on reverse mortgages other than to say, if you're a lender in our state and you offer reverse mortgages, the borrower has to be counseled. So many states require counseling. In addition to pre-application counseling in over a dozen states, it's closer to 24. 9 states have reverse mortgage cooling off periods or similar waiting periods. And this has been, I say recent, but we've been at this for a while. I think the first state to do this might have been California. And there was a sense out there at that time, as I said, rightly or wrongly, that borrowers were being rushed through the process. So the overriding themes here are that there's either a waiting period under a counseling protocol to take an application, or there's a cooling off period after you've taken an application and processed a loan, but before you've issued a commitment. Next slide, please. So these are some of the states, and I just pulled out some rules of states. So in California, you may not take a final and completed application until 7 days after receipt of a counseling certificate. The Department of Business there, it's now the Department of Financial Protection and Innovation, issued a bulletin that making California more or less consistent with FHA rules. But you know what, with the new handbook, and Ellie's going to talk about the new rules, we need to go back and look at that California bulletin because it was geared off of the mortgagee letters that Ellie discussed, 04-25 and 06-25. It referenced those mortgagee letters. As Ellie will share, I think that under the draft handbook, HUD is being more liberal and listing more things and that are allowable as part of early processing, but that may not be consistent with the prior named California regulators' interpretation of the California Civil Code. I'll also mention there's issues in California with counseling. Certain disclosures have to be given prior to counseling. One of them, it says the lender or the counselor can give it. The lender gives it if the borrower goes to the counselor first, and the counselor's supposed to give it. But the other one, the lender's supposed to give it before counseling. And the problem with that disclosure is sometimes a lender will be dealing with a borrower that's already gone to counseling. And that is a glitch in the California law that has not been clarified. So we have more work to do in California. That's a big state. In Illinois, a borrower may not be bound for 3 full business days after the borrower's acceptance in writing of a lender's commitment, a lender's written commitment, and a borrower cannot be required to close or proceed with the loan during that time period. And this cooling off period, this waiting period in Illinois, like other states, is non-waivable. The borrower cannot waive this right. In Massachusetts, an applicant for a loan should not be bound for 7 days after acceptance in writing of the lender's written commitment to make the loan. In Minnesota, the borrower may not be bound for 7 days after receipt of lender's written commitment and cannot be required to proceed with the loan during this period. In New York, fairly new rules that apply to HECMs went into effect over the past couple of years. There's a 3-day cooling off period after submission of the application. During this 3-day period, the borrower cannot be required to sign a commitment or proceed with the loan. Rhode Island has rules that are similar to the HECM rules. In South Carolina, a lender may not accept an application until the lenders receive the statement regarding the advisability on counseling. In Texas, counseling must not have occurred until later than the 5th day prior to closing. And there's also a 12-day waiting period prior to close in Texas. And that has to be documented by an important notice disclosure. These rules in Texas are definitional. They're in the definition of a reverse mortgage in the Constitution. If you don't meet these rules in Texas, arguably you don't have a good lien on a non-recourse loan. That's not a good thing. In Utah, before an applicant signs an application, he must go through counseling, and there's a 7-day cooling off period after the commitment is issued. Next slide, please. So this used to be the $64,000 question, but because of inflation, it's now a $64 million question. And the question is, what's an application? We've been struggling with this issue in the mortgage industry for years. And, you know, the lawyer answer, everyone hates this, especially even some lawyers, you know, and the weasel words are, well, it depends. It depends what an application is. It depends under what rules you're operating and what rules you're trying to meet. For RESPA purposes, an application for reverse mortgages, it's different now for forward with TRED. For RESPA purposes, for reverse mortgages, an application means the submission of a borrower's financial information in anticipation of a credit decision relating to a federally related mortgage loan, which includes a HECM, whether it's open-end or closed-end. And the information includes the borrower's name, the borrower's monthly income, social security number, property address, estimate of the property value, the mortgage loan amount, and there's a catch-all, any other information deemed necessary by the loan originator, which could be a broker or a lender, necessary for the application. That catch-all was taken away in the forward industry, but we still have it in reverse. Then there's GFE timing, not later than 3 business days after the lender receives an application or information sufficient to complete an application, the lender must provide the borrower with a GFE. Well, until you have all this information, you can issue a GFE earlier than you have these 6 or 7 items. But once you issue the GFE, you're sort of bound to that GFE subject to other rules, change circumstances and other things we won't go into here. The point is, you shouldn't be issuing, I think, GFEs early until you have, you know, sufficient information. And let's talk about that. How can you issue a GFE if you don't have an application or you don't have enough information sufficient to complete an application? You know, that bears some thought process. So next slide, please. I'll just mention this. This is not directly on point. I stuck it in here and I'm segueing this or wedging it between RESPA and TILA. But this is more of an application processing rule. Under the Equal Credit Opportunity Act, there are processing timelines that apply to creditors. And the creditor has to notify the applicant of what the creditor's done with the application. Now, under ACOA, the definition of application is a little bit different than under RESPA. It's whatever the creditor deems the information necessary that it needs to make a credit decision. But that's important because once you have an application, these timelines take place. I have seen some lenders make their policies and procedures consistent. They say, we're going to use the RESPA definition of application for a COA so that we can more easily comply with both laws and work off of the same timelines. But once you have an application under a COA, you have time limits on what you have to do. And 30 days after you receive a completed application, you either have to approve the loan or provide a counteroffer and say, you applied for this, we can't give you this, but we can give you something else, or make an adverse action and notify the consumer of that on the application. Now, that adverse action does not have to be a pure turn down. It could be a notice of incomplete application. You could go back to the bar and say, listen, your application is incomplete. We need more information, but this has to be done within 30 days. And then 90 days after notifying the applicant of a counteroffer, or if the applicant doesn't follow up or expressly accept the credit offered or the counter offer, or doesn't complete an incomplete application, after 90 days, you have to close that application out. You have to send a turn down notice. We see in the industry, forward and reverse, lenders struggle with this and they don't want to issue a turn down. And the problem is if you do nothing and that application sits on your pipeline, it's 180 days out. Well, you've got all sorts of problems in non-compliance, not the least of which is that application is now stale for HECM purposes. But you've also not taken action under a COA. And what a lot of lenders like to do is just mark that application as withdrawn. Well, that may not be technically correct. Next slide, please.
Hey, Jim, can I insert a question? So there's a couple of questions that have come up. And someone just asked, Glenn Smart says, with some appraisals taking 30 days or more, what should the notice of incompleteness state?
Well, you could define your application off of when we receive, an appraisal. You could say that's what it is, but that's the problem. You don't have to define it that way, but that's the problem, Ellie. If you issue a GFE early on without waiting for an appraisal, you sort of box yourself in. I mean, that's the whole point of what we're discussing here in terms of looking at your policies and procedures. You don't have to wait for an appraisal to issue a GFE, but if you issue a GFE, a different value on the appraisal could constitute a changed circumstance, which would necessitate the issuance of a new GFE. But the only thing that could change under that changed circumstance would be things related to that changed item. And we know in the reverse world, the property value determines the MIP and could determine the origination charge. Not to delve into other issues because there's a lot more we could talk about here. And I see all the questions coming in. Maybe, I know we have about 15 more minutes here, I think. We have 20 more minutes. Maybe we need to do another mini session on this topic in the first quarter of 2020 if everyone wants to do that. But, with the GFE, we see in our practice, a lot of people seem, well, I got a new appraisal, that's a changed circumstance. I can issue a new GFE with all sorts of new things on it. No, that's not right. You're limited as to what you can change based off of what the changed circumstance was.
Right.
We have a lot of questions coming in. Ellie, you have any others you want to flag?
One other that I think is important, because when you were going over state by state, you had a list of the very specific state requirements. Mm-hmm. So Bruce Simmons has asked, how do I find out specific rules in my state? Where do you go to find out these?
I would say this, I'll make an offer to everyone since you're NRMLA members. Here you go. Call Ellie. And if she doesn't know, she'll call me. I'll give her the answer. And then she can pass it along to you, because Ellie and I do that sometimes. And but she's not a lawyer, so her fees are not as high as mine. And she won't be accused of engaging in malpractice if I get the answer wrong, but I'll get the answer right. So if you have questions about any of this stuff, particularly if you're originators and you're at smaller shops, you can call me. Listen, I don't mind, but I would encourage you to reach out to Ellie. I will tell you, Ellie, I hope you don't mind me sharing this with the group. Ellie and I work together. I learn as much, if not more, from her than she may get from me. We're constantly talking about these questions, and these questions we're talking about today have come up in numerous times in our conversation. That's why we decided to do the panel. So if you have questions about this stuff, I would suggest you reach out to Ellie, and if she wants to bounce it off of me, we can talk about it. We often do this by email, so it's fairly quick, but I hope that some of you will take up that offer and you will find it of some value. Any other questions you want to address, Ellie?
No, I think we should probably move on.
Yeah, I want to discuss TILA, and we have 15 minutes left. I think I just have a few minutes to wrap it up. And guys, we will try to get to as many of your questions at the end, but I know we have a hard stop, Steve, Daryl, I think at 1 o'clock, right?
Jim?
Yeah.
We have purposely put a break in. Yeah.
Okay, well, we don't want to cut into people's lunchtime. We'll
Okay.
end at 1. We can end at 1, but Daryl or Steve, if you have a way to gather up these questions, we can look at them. And Ellie, while I'm talking about TILA, you may want to put your email and contact telephone number in the chat room so everyone will have it.
Absolutely.
Yeah.
If you're willing.
Yeah, if you're willing. I don't want to twist your arm. Let me talk about TILA a little bit. So under the Truth in Lending Act, we really have 3 sets of disclosure rules. And we know that the TALC and the reverse mortgage rules apply to all reverse mortgages. But then we've got additional disclosures depending upon whether the loan is an open-end credit or closed-end credit. And for our purposes in the reverse mortgage industry, for the most part, I would say for all parts, variable rate loans, whether they're proprietary or HECMs, are structured as open-end credit. And fixed rate loans are structured as closed-end credit. It's not that all fixed rate loans are closed-end or all variable rate loans are open-end. We know in the forward world, adjustable rate mortgages, which is a variable or an adjustable rate, is a very popular product in the forward world, and that's a closed-end loan. We don't have those in reverse, but for open-end credit under TILA, the rule is neither the creditor nor any other person, and I went to pains to highlight that with bold underline italices, neither a creditor or any other person may impose a non-refundable fee in connection with an application until 3 business days after the consumer receives the early TIL disclosures, the application disclosures. And again, those disclosures are required, within 3 days, similar to the GFE as when you receive an application. So you have to give the early TIL disclosures and the brochure when your home is on the line. You can mail these things, and if you mail them, they're presumed received 3 days after you mail, but you can't charge any fees before this time. How are you going to charge an appraisal fee? How is another person going to charge an appraisal fee? If you go out and ask the borrower for their bank account number or a credit card prior to this time, I think that's a problem. And we have a similar rule under closed-end credit. And these rules were updated for closed-end in 2008 to make them consistent with the open-end rules. And again, what was the policy then? We're coming out of a meltdown, or the Federal Reserve, which owned TILA at the time, saw that we were going into a financial crisis, and they were trying to put in more consumer protections. What was this addressed to do? It was to say you cannot charge certain fees before you hit certain milestones. That was the policy behind this. It was consumer protection. And let's think about the customer base we're dealing with here. It's seniors. So under closed-end credit, a creditor has to provide the consumer with good faith estimates of the TIL disclosures. That's the closed-end disclosure with the federal boxes no later than the third business day after the creditor receives an application, except, I've got a typo there, sorry, except for a credit report fee, neither the creditor nor any other person may impose a fee on the creditor in connection with the consumer's application before the consumer receives the early disclosures. That's the creditor or any other person. That's the rule in TILA. It applies to all reverse mortgages, whether they're HECMs or otherwise. Next slide, please. Ellie, I think I'm going to turn it back over to you now on slide 13 if you want to go through this.
Okay, thanks, Jim. All right, so a lot of information. I know we're talking about a lot of different regulations and rules, and we're talking about HUD and what HUD requires and what HUD will allow. But so we're going to kind of look back to, so what does this draft handbook say? And I did see a couple of questions in the chat. I'm going to talk about some of those in just a second, but mortgagee and or sponsored TPO may perform, this is what the new draft handbook says, okay? May perform only the functions listed below before all required HECM counseling has been completed. And it also goes on to say by all individuals to receive counseling. Okay, so that's, I'm going to talk about that too. So first, accept the loan application and provide required disclosures. Lock in the expected average mortgage interest rate, the expected rate. Explain the HECM program to the borrower. Discuss whether the borrower is eligible for HECM. We talked about that earlier. Provide information regarding the fees and charges associated with the HECM product. Describe the potential financial implications of a HECM for the borrower. Provide the borrower with sample copies of the HECM note, mortgage, and loan agreement. This next one I have underlined, order preliminary title report versus preliminary title. And that's a change in terminology. We're going to talk about that a little bit. Order automated valuation model, an AVM. Order a credit report to perform a preliminary credit review of the borrower's financial obligations. Now, that's what the new handbook says. There's a few things that have been added. So, you know, in the past, credit report, you couldn't order a credit report, you couldn't order title, you couldn't order certain items, okay? But now, again, with the introduction of financial assessment, they've made some provisions that would allow the lender to be able to make a better informed decision for the borrower before the borrower has any obligation or any charges made to them. So the guide goes on to say, the mortgagee and sponsored TPO may not collect, very clearly, may not collect any fee or the borrower's banking account and credit card information before closing or in connection with any function permitted above. So everything that I just talked about, that little list of items that they said you could do before counseling, but they're saying that with any function permitted above, if the function is performed before receipt of a signed and dated counseling certificate, signed and dated, dated is a key word there too, for each individual required to be counseled. So someone asked earlier, so when can you order a credit report? How early can you order a credit report? Well, the new guide says you could order one before the borrower is counseled, okay? It does say that clearly, but there are provisions about when you can actually charge the borrower for anything, okay? Jim, I'm gonna jump to a question or just kind of get your input on what I just read and what does this mean exactly? So an issue came up recently around the wording order preliminary title versus order preliminary title search, report versus search, okay? The parties were discussing, well, do we think that is a full title report or does it mean that they can order full title? Or are you still just limited to just some sort of preliminary work, okay? Either way, I think we know the borrower can't be charged if they don't go forward. Mm-hmm. And then, of course, you know, I just cited what the new guide says relative to charging a borrower and even collecting credit card information. So we kind of breached on that just a few minutes ago. But Do you agree that what I just read about collecting credit card information and that type of thing, do you agree that this is basically saying that you cannot collect a fee prior to closing?
No, I think that you cannot collect the fee prior to counseling. So, you know, once they go through counseling and submit an application, I know a lot of closing fees are paid out of borrower proceeds at closing, and people are not charging borrowers fees prior to closing, with the exception of the appraisal fee. But I think, and I want to answer two questions, preliminary title, but this issue of in the handbook, cannot collect the borrower's banking account information or credit card information before closing. Yeah, on that issue, the handbook does say closing.
Yeah.
So, you know, I think we might want to ask for clarification on that point, but if that were clarified to be before counseling or before application, I think that that would be consistent with the rules under both RESPA and Truth in Lending. And so, you know, I see all the comments coming in, and we knew that this might be a charged and might even say emotional panel, but I think it behooves everyone to not only be paying attention to what's going on with this draft proposed handbook, HECM handbook, but also to go back and look at your own policies and procedures and make sure that they're aligned with the rules that are in place under other laws, other federal laws, Truth in Lending in particular, and maybe even some state laws on cooling off periods, because the questions we're being asked here are the same questions that we are asked, not every day, but often in our practice. And I've had occasions to answer questions and say, well, wait a minute, you can't collect an appraisal fee. You can't send the appraiser out to the senior's house to ask for a credit card before counseling. And the response I've gotten to that was, what are you talking about? Blank stares. So I just think we need to do a reset, you know, as to how these rules work today and what we're heading into with respect to this draft handbook. I mean, we have the language right here on the screen. So I'm not sure that answers your question or not. I apologize.
Right. Well, again,
conceptual.
I think, and there's one other little piece to this that I want to just bring up as well. So in some of our discussions, that some of the lenders indicated that there were many times it was not unusual to discover in the process that there is a non-borrowing occupant after you've already started the process and you've ordered services. And since the NBO, non-borrowing occupant, must be counseled, does that mean that you can't charge for the appraisal, et cetera, if you had already ordered that? I mean, so a lot of questions here that, you know, you have to really consider.
Yeah, Daryl, I would ask if you can save everything coming in the chat room and the Q&A. I think it would be very helpful to me to look through these, because we're not going to have time to get through all these questions. We have had over 24 questions pop up in the Q&A and in the chat room.
And we anticipated that. We did.
Yeah.
I mean, I think we anticipated that we would have a lot of questions. So we're happy to follow up with answers to a lot of these questions. I will say again, back to something that Jim had mentioned, you know, it's really important that everyone get the guide, look at the draft guide, go through it. It's 400 and some odd pages. I know it's a lot of reading, but I think it really behooves you to get the guide, to go through it, go and give your comments. So HUD did allow us. Initially, our comment period was November 15th, but they did announce during this conference or just before that they have extended that to December 31st. So everyone does have opportunity to take a look, go through it. They've provided a spreadsheet, which I think they did an excellent job. I will have to say, I think it's as far as putting that spreadsheet together for tracking what your comments are. Yeah, I do know that HUD stated during the conference that stakeholders, they say, are encouraged to thoroughly review and provide their feedback on the draft sections, and that HUD said they will carefully consider all feedback received. So please make sure that you, if you don't have it, that you go and you get it and you go through it. I did see a comment where someone asked, where can we get a copy of the draft guide? FHA Info 21-81 announced the guide. I think you can also probably go to www.hud.gov and you can search it there. But you should be able to get it in that FHA Info. There's a link to it. Encourage all of you, please go and take a look at that. And there's a lot of things. I think there's a lot of wins for us. I mean, if you look at certain sections of the guide, you see that they did make some changes that we would consider a win for the HECM product. And in many respects, it appears as though HUD was working to align the guidelines with the forward and the HECM. And they even said in the industry call that they had a few weeks back that was their intent, to try and align the guidelines between forward and reverse as much as possible. So again, can't encourage you enough to get your hands on the guide, go through it, and please provide your feedback. Jim?
It looks like Misty Likas just posted a link to the guide. I was also going to say, I thought Daryl put a link to the guide in the weekly report a few weeks back, but Daryl, maybe for those who are not listening, and if you highlight or summarize this panel tomorrow in the weekly report, maybe you could add a link there so that everyone who's getting NRMLA's weekly report as an alert in their email will see a link to the handbook. So
there is.
Yeah. Okay.
Hey, Jim,
But you can also go to nrmlaonline.org.
Perfect.
Okay.
nrmlaonline.org. I have to say there's a couple of things here that I have to mention. So Lisa says, I'm more confused now, but she also says, please show me the page that gets rid of the second appraisal requirement. I wish I could say we could show you that page, but that's not going anywhere. Okay, HUD has said multiple times that the collateral risk assessment is having its intended effect. So we don't anticipate that that's going anywhere. So unfortunately, I can't tell you. I can't give you that page number.
Yeah, and we have about 2 minutes left. So just to wrap it up, and there's people asking lots of questions here. We apologize. We're not going to be able to get to them all, but we'll try to look at them. If Daryl can capture them in the Q&A and the chat boxes, we'll try to take a look at them. But Daryl, if you want to go to the last slide and we'll just wrap it up. So what are the takeaways here? If you're confused by all of this, I would say to review your policies and procedures. Go back and look at those and have the people who are responsible for putting those together review them in light of the laws and regulations, and not just against what you've been doing. We've always done it this way, or what others are doing. We have a new handbook coming out. And as Ellie's explained on some of these issues, it appears HUD's trying to make the rule consistent with rules that are already in place under particularly the Federal Truth in Lending Act. So review your policies and procedures if you're confused. Have people you work with, your internal administrative support. If you're not a big company and you don't have that, work with your sponsors. Go through this. I would behoove everyone to understand the policy reasons behind the rule. And it's not to make your life miserable or to make your life harder. It's all about consumer protection, informing consumers, and trying to assure under multiple laws that the consumer does not feel obligated to proceed with the transaction until they're ready, and that they don't incur any cost. If you look at the rules holistically, that's what they're designed to do. And no one is saying that anyone's trying to rush or push seniors along. But by the same token, no one should be trying to do that. You know, we know these loans have a long origination timeline. And when we get to the proper point that the senior wants to proceed, you know, we know that a lot will have been done at that point, but don't get caught up on these hyper-technical rules or get confused by them. Make sure you understand what they are. Talk to your compliance people, make sure your policies and procedures meet that. And again, I'm repeating myself, in that regard, stay up to date with the changes in the regulations and the handbooks and get ready for changes on the horizon. We got an extension to comment on the HUD, proposed draft HUD HECM handbook. Ellie is heading that up on a task force for NRMLA on the origination side. The servicers are looking at their issues. We're supporting those efforts as NRMLA outside counsel. We got an extension till the end of the year, but if you have not looked through that handbook, Daryl sent out the links. The links have been shared in the chat room in this Q&A, in this webinar. I would encourage you to print it out. It's over 400 pages and look through it and consider. And if you have concerns about second appraisals or anything else, let us know. Feel free to email, because we're putting together comments and we're going to comment on a lot of what's in these 400 pages. With that, I'll turn it back over to you, Ellie, for any final words, or turn it back over to our sponsor and our host.
Okay, so real quickly, I would just like to say, I did see a comment here. Will NRMLA advocate for members on some of the items in the proposed handbook? Absolutely. As Jim just mentioned, I'm working I have a working group that has convened, and we are going through the handbook in conjunction with NRMLA. And NRMLA will put together a very well presented letter to HUD with their comments. And obviously NRMLA was instrumental in getting the extension of time for us. So we were kind of pushing it to get to the 15th, but now we have a little bit more time to go through the handbook. And so just expect that, yes, NRMLA is very much involved, as is Wiener Brodsky and Jim Milano and that team as well. So again, look forward to your comments. We'll get to your questions, many as we can. Please reach out if you have anything specific for Jim and I. And we thank all of you for being here today.
And I thank you both very much.